When we think of lawyers, we usually picture these cold, calculating professionals just applying a strict, objective rulebook to their client's situation. But what happens when that rulebook gets a little blurry? What happens when a lawyer's own personal beliefs quietly step in and steer the ship of legal interpretation? Welcome to This Explainer. Today, we're unpacking an absolutely fascinating analysis by legal scholar Robert K. Vischer. He's looking at the hidden moral choices disguised as objective law. Vischer argues that the whole idea of a purely objective lawyer, it's a dangerous myth. So we're going to look at the nuts and bolts of this myth and see exactly how it played out in two massive modern scandals. Let's get right into it.
To really set the scene here, take a look at this quote. It perfectly captures the intense public outrage that followed the leak of the Department of Justice's 2002 Office of Legal Counsel memoranda. We're talking about the infamous torture memos. These were documents that provided a highly aggressive legal analysis, essentially facilitating the abuse of suspected terrorists. And when these leaked, coming right on the heels of the Abu Ghraib prison photographs, the American public was literally stunned. Critics from across the entire political spectrum, red states, blue states, you name it, completely condemned them. As one journalist famously put it, it read like the advice of a mob lawyer to a mafia don on how to skirt the law and stay out of prison.
But, and this is the crazy part, much of the legal profession actually shrugged the memos off. Prominent legal scholars, former officials, they stepped right up to defend the work, calling it just standard lawyerly fare, routine stuff. They argued there was absolutely nothing wrong with exploring any topic just to find out what the legal limits are. To them, it was merely an abstract analysis of a treaty and a statute. No big deal, right?
So look at this stark divergence. On one side, you have the public experiencing deep, visceral moral outrage over these twisted definitions. On the other side, the legal profession is defending it as standard practice, focusing purely on legal merit over morality. Now, Vischer points out something absolutely crucial here. This wasn't just a guild-like protectionist mentality. It wasn't just lawyers circling the wagons to protect their own. It was actually a reflection of how the legal profession fundamentally views its entire relationship to morality.
Part 1. The Amoral Technician Myth.
This brings us to the core conflict. To understand how a lawyer could write a memo justifying extreme physical pain and still sleep soundly at night, we have to look at the ethical framework governing the profession. The legal profession operates on a strict, at least a purported, demarcation between legality and morality. The Model Code of Professional Responsibility actually provides that clients are entitled to seek any lawful objective through legally permissible means. Basically, the lawyer's job is simply to provide information on the law, and they leave the moral implications entirely up to the client's discretion.
So the crucial takeaway here is that lawyers are trained to be amoral technicians. What does that mean? It means a lawyer pursues a client's vision of the good through the maximization of legal rights, without injecting their own moral vision. Their own personal disgust towards something, even something as extreme as torture, is considered completely irrelevant to the legal advice they provide. They are explicitly instructed not to inject their own vision of good into the representation. Whether the attorney finds the client's actions abhorrent doesn't matter. The job is to maximize the client's legal rights. But, as we're about to see, completely separating law from morality is practically impossible.
Part 2. Inside the torture memo. Let's look at our primary case study to see how this amoral technician theory works in the real world. We're looking forensically at Assistant Attorney General J.S. Bybee's August 1, 2002 memorandum. Bybee was asked by the White House to outline the legal limits on interrogation under the Convention Against Torture. Obviously, this was an undeniably high-stakes assignment in an unprecedented national security climate. The administration essentially asked, how far can we go? And the way Bybee formulated his answer is Fischer's key example of how personal judgments quietly shape supposedly objective legal analysis.
The governing statute prohibited the infliction of severe physical or mental pain, but it didn't actually define the word severe. Now, if you open a dictionary, it sensibly defines severe as pain that is simply hard to endure. And logically, that makes perfect sense, right? The whole point of a coercive interrogation is to inflict pain that is too hard for the subject to endure, so they give up information. But Vischer points out that Bybee flat out rejected this broad common sense definition because, well, it would restrict too many interrogation techniques.
Vischer refers to what happens next as jurisprudential gymnastics. It highlights exactly how Bybee arrived at what many considered a totally shocking conclusion. Step 1. He entirely sidestepped that common-sense dictionary definition. Step 2. He went looking for another place in the law that used the phrase severe pain. And he found it in, of all places, a completely unrelated Medicare health benefit statute that dealt with defining emergency medical conditions. Step 3. He literally copy-pasted the criteria from that health statute to conclude that to qualify as torture, the physical pain must be equivalent in intensity to the pain accompanying organ failure, impairment of bodily function, or even death. By doing this, he created a massive legal loophole practically out of thin air. And he did the exact same thing with mental pain. Bybee unilaterally decided, without any supporting legal or medical citation whatsoever, that the mental strain of a lengthy interrogation just wasn't enough. He claimed that mental torture must cause psychological harm lasting for months or even years, like PTSD, to actually be considered torture. Again, this temporal requirement of months or years was a standard entirely of Bybee's own creation, specifically designed to widen the boundaries of what was legally permissible.
Part 3. Morality disguised as law.
Okay, let's step back and look at what was actually happening here. Vischer points out that Bybee's analysis wasn't driven exclusively by the settled meaning of governing legal directives. Instead, personal morality was driving these seemingly objective legal definitions. And perhaps the most revealing line of the entire memo, Bybee writes, "Clearly, any harm that might occur during an interrogation would pale to insignificance compared to the harm avoided by preventing such an attack." He is actively arguing that the pain of one person is insignificant compared to saving thousands of lives. Now, labeling harm to an individual as insignificant to avert a terror attack, that is an intensely normative, moral assertion. It's not a strictly legal one. Vischer maps out how Bybee's conclusions were deeply rooted in unarticulated moral views. Take a look at this breakdown. For example, relying on a necessity defense to the torture statute is essentially utilitarianism. It's the moral belief that the collective good simply outweighs individual harm, that it's morally acceptable to harm one person to save many. And when he narrows the statutory definitions using those Medicare laws, he's operating on the moral premise that maximizing executive discretion during wartime is the paramount good.
Vischer's main argument here is that whenever the law is indeterminate, meaning it leaves gaps or uses vague words like severe, an attorney's interpretive judgment is inexorably shaped by their own moral perspective. A lawyer cannot connect ends and means in a vacuum. Their own life experiences, their ethical prejudices, their worldview. It all acts as a lens filling in those gaps. So they might pretend to be amoral technicians, but they are actually filling those legal gaps with their own ethical prejudices. This means the lawyers designing the rules that govern our society aren't acting in a vacuum. Their personal biases are baked right into the outcomes that affect us all.
Part 4. Why moral dialogue matters.
Let's move to our final section and see why hiding these moral perspectives behind complex legal jargon is so incredibly dangerous for clients and society at large. This danger isn't just limited to high-stakes government intelligence. It extends right into the corporate world. Fischer uses the tragic demise of the energy giant Enron as a prime example of what happens when lawyers suppress this moral dialogue.
In the Enron case, the company's lawyers were so enmeshed in the management culture that they adopted what Vischer calls a reflective moral perspective. Basically, they uncritically adopted their client's presumed goal: maximize the share price at all costs. Because of this, their legal advice became tailored exclusively to that one single goal, entirely excluding the company's long-term interests. By turning every issue into a purely technical legal puzzle, the lawyers allowed Enron's managers to completely avoid facing the moral implications of manipulating the law. They foreclosed any meaningful moral dialogue that might have actually saved the company from its catastrophic collapse.
The overarching takeaway here is that clients are ultimately better off when an attorney's moral perspective is articulated openly. Think about it. If Jay Bybee had explicitly stated his utilitarian assumptions to the White House, it would have forced decision-makers to consciously agree or disagree with sacrificing human dignity for intelligence. If Enron's lawyers had explicitly discussed the moral risks of their financial shell games, the board might have paused. Explicitly discussing moral assumptions enriches decision-making. Bringing morality to the surface forces decision-makers to confront the true weight of their actions, and it prevents them from falsely equating technical legality with moral permissibility.
I'll leave you with this provocative thought to ponder. What is the true cost to society when we allow lawyers to strip human morality from the application of the law? If the convenient fiction of the amoral technician is what allows catastrophic ethical failures, from torture memos to massive corporate frauds, to hide safely behind legal technicalities, is it time we fundamentally change how lawyers and clients talk to each other? Thank you for joining me on this explainer, and keep questioning the frameworks behind the facts.